Let's start with what's at stake here, the survivors. The vast majority of sex assault survivors don't get their day in court. We heard about that the other day. Either the accused is acquitted or not charged in the first place. So where does that leave survivors like Jules Pierre Roselli?
I know myself, and I know who I am, and I'm not a liar. I'm not out here saying that this person assaulted me for what? That person sexually assaulted me. That is what happened to me. He did that.
What's going wrong in this situation is this. First of all, survivors don't have any real say in how a case is going to proceed in court. The first time Jules Pierre Roselli, for example, heard from the Crown Attorney in her case was 5 months after she'd reported the assault, only to be told no charges would be laid. And then there's Isabel Daniels. She's also a survivor. Her case did go to court, but on the day she was scheduled to testify, she was told a deal had been struck and the accused got house arrest. Alexa Barkley is both a survivor and an advocate, and she puts it this way.
They really don't want to hear from you, generally speaking, which I know is a huge frustration for survivors. I mean, we are the ones that have been hurt. We have the greatest amount of skin in the game, quite frankly.
In a court proceeding, the victim is just one witness and is treated so accordingly. But the big issue is proving there was no consent. Here's Jules Pierre Roselli again.
The one question that, one of the officers asked was well, did you say no? And that just implies that the answer is always yes, otherwise, and that's wrong. And really, what are we asking? Did you say no? Well, did I say yes? No, I didn't. I didn't say yes, ever. So why did you ask that?
Donna, what are survivors supposed to make of that? What do advocates say about that?
Well, here's what Alexa Barkley's take is on it.
I think it's because the burden of proof is so high to actually convict somebody. So you need so much evidence about consent, and so they're looking for, easy ways to determine that. Well, did you say no? Well, then obviously, if you said no, then you did not consent. But it's just there's so many scenarios, especially when you slip into that survival mode.
Speaking of that survival mode, those scenarios can range from being too scared to actively fight off their assaulter because they don't want to escalate the situation, or sometimes they just freeze. They're actually unable to physically react. Sometimes they disassociate. All of this, though, Faith, is in an effort to survive it.
I hear that all the time from women who have been sexually assaulted, especially when it happens like date rape, right? And again, people do not understand what it's like to be a woman in a situation with a person that can overpower you. All these things go through your mind, and it's how do I stay alive? And that's what it comes down to.
So that was Isabel Daniels. Now, Karen Bellhumer, she refers to this as the fight, flight, or fawn scenario. She's a former Crown Attorney out of Ontario. She now works with sex assault victims. She says the courts just don't fully understand what the brain does during a traumatic event. And without that understanding, it can really be tough to prove in court what lack of consent looks like.
Donna, how can the justice system, as we know it, fix these issues?
Well, first of all, it's really important to note that these are not new issues. So earlier this week, I'd referred to some statistics that reveal the vast majority of sex assaults go unreported. And of those that are reported, the vast majority end up without convictions. This is nothing new. And the justice system has known this for decades. Back in 1991, the Supreme Court of Canada singled out sex assault cases as being particularly problematic. And I'm going to quote, "Sex assault is not like any other crime. It is for the most part unreported. The prosecution and conviction rates for sex assault are amongst the lowest for all violent crimes," end quote. The Supreme Court even then acknowledged the impact on the victims themselves. And I quote again, "Perhaps more than any other crime, the fear and constant reality of sexual assault affects how women conduct their lives and how they define their relationships with the larger society," end quote.
This was back in 1991.
Yeah.
Here we are almost 35 years later.
Yeah.
What have the courts done about it?
So a few things have changed, but importantly, they come with caveats. So let's start with this understanding of consent and what it looks like. In 2021, the Federal Department of Justice passed Bill C-3. So it means that any incoming judge in a provincial superior court must agree to participate in continuing education on matters related to sexual assault law and social context. And that includes the concept of what consent is and isn't. Here's the but. It's for incoming judges only, new ones. And that, says Alexa Bartley, is already proving to be problematic.
But judges who have been practicing already are not required to take that training. It's only new judges. So we're sort of dealing with an uninformed group of people who are making decisions on sexual assault cases that they really have no business making, quite frankly.
What does she mean by that?
Well, it turns out last year, for example, an Ontario Court of Appeal determined that criminal trials don't need expert evidence explaining the neurobiology of trauma because judges and jurors already understand that so-called failure to resist concept that's often wrongly interpreted as consenting. But advocates say recent trial outcomes suggest some judges still don't get that. In one case, the trial judge didn't buy the victim's explanation of why she'd acquiesced to the assault.
Whereas, I'm sitting in the courtroom with a bunch of survivors and survivors advocates, and we're all like, yes, that's exactly what happens. You do that to survive, and she didn't understand it.
What about closer to home, Donna? What is the legal landscape here?
So, as you know, we heard from two Crown attorneys from Manitoba Justice who talked us through the legal challenges yesterday. So first and foremost, there's the non-negotiable. This won't ever change. Some cases just won't make it to court. The victim's telling the truth, but it's not enough to proceed with charges. Chantal Boutin puts it this way.
In order for a case to proceed, of course, we have to ensure that there's a public interest. There almost always is in cases of sexual violence, but also that there is a reasonable likelihood of conviction. And that is the particular aspect that can lead to a matter not proceeding. And that's in light of all the evidence that's available, an assessment of all of that evidence.
So what has changed then?
So training, for starters. Any Crown attorneys who want to work with sex assault cases now have access to sex assault training and a community of experts who can help inform them. And as for the victims themselves, Manitoba Justice offers the option of what they call testimonial aid. So here's how that works. If a victim's under 18, the courts will automatically provide someone, either from community or otherwise, to be with them during testimony. But here's the but. It's automatic, as I said, for those under 18. For adults, the Crown has to request one.
What about other changes that have been made locally?
Remote testimony. So just this year, in fact, the Crown appealed an acquittal of a sex assault where the survivor hadn't been permitted to testify remotely. So they won that appeal, and a new trial has been ordered, and the victim will get to testify from away. This can be important for survivors outside the courts, perhaps, where they can remain within their support network and testify without prejudice.
Speaking of survivors, Donna, are there any other supports being put in place for them?
So here's one big change that advocates are calling for, and most provinces aren't yet on board. It's the idea that sex assault survivors themselves have legal representation in court, just like the accused.
What do you mean?
So Karen Bell-Humer, again, she's leading the advocacy on this. She's the former Crown attorney out of Ontario, so she envisions a system where as soon as a survivor presents to authorities, they're offered free legal counsel, a lawyer.
How come?
So they can have a legal advocate who has their back. Now, remember, Crown attorneys are not the victim's lawyers. The victim is one witness in the Crown's case, so they're not privy to any of the behind-the-scenes activity in the case. A lawyer of their own could, at the very least, talk them through the process. But more importantly, Karen Bell-Humer says a lawyer could protect them.
Talk more about that, protect them. What does she mean?
Okay, so for example, as she explains it, anything the victim tells the police or the Crown must be disclosed to the defense. There's no confidentiality in relationship with either, right? Their lawyer might protect them from that. Here's an example she cited. So say a survivor tells police that the PTSD they've suffered since the assault, it's not, for a variety of reasons, evidence that the Crown can necessarily use to prove the assault occurred. But Karen Bell-Humer says it would be available for the defense, and the defense could then turn around and use it in a way to undermine the complainant's credibility. Her lawyer could perhaps guard her against that.
What's been the reaction to this idea?
Depends on whom you ask. Advocates like the idea, defense lawyers are not so much. Next week, the Federal Ombudsman for Victims of Crime is releasing their special report on how the justice system handles sex assault cases. With it will come recommendations on what needs to change. We'll see if this is one of their recommendations.
And Alexa Barkley lent her voice to the task force's research on that report, didn't she?
That's right, and that's why she and Karen Bell-Humer will be watching for those recommendations. In the meantime, Alexa has this message to deliver to other survivors like Isabel Daniels and Jules Pierre Roselli.
So first, I'm just so sorry for what you've experienced. The system is not built for us. Yeah, so I think those are my big two messages. You're not alone. It's not your fault. And the system is super broken.
Thanks for this, Donna.
You're very welcome, Faith, and I really just want to thank all of the survivors who shared their truths with us. Isabel Daniels, Jules Pierre Roselli, Alexa Barkley, others who weren't ready to go on camera with their stories. We can't tell the stories without their truths.
Really appreciate your work on this. Take good care. Donna Carreiro, producer with CBC Manitoba. For more on this special report, you can visit our website, cbc.ca/Manitoba.